The ACC lawsuits are always in the news, so we're back on the Big Mountain with a very special guest.
Hey, good to have you back on the mountain. I am JY. This is my good friend Steve, and we have Doug Rohan back with us to help us understand a little bit about what's going on today with the lawsuits between specifically FSU and the ACC. I know there's a question that I have that's been burning in my brain for the last couple of weeks, and I'm hoping Doug can set me straight. And I also want to hear from Doug to see if there's any interesting tidbits that he can give us coming out of this much awaited document that AG Moody has now gotten for the taxpayers of Florida.
Right.
I might be being a bit rude about that.
They know you love AG.
They know I love her a lot. But anyway, Doug, hey, welcome back to the show. Good to have you on.
Thanks. It's a pleasure. You guys are doing a great job, and it's always fun to come alongside and chat with you all a little bit about Florida State and the lawsuits and my two big passions.
Well, we appreciate your time. Go ahead.
I'll just say real quick for any of our Big Ten fans and obviously Florida State fans, if you're not following Doug on Twitter X, what's your Twitter X handle, Doug?
At Rohan Law PC.
Okay, so if you're a college football fan, you're a Big Ten fan, you're a Florida State fan, and you're interested in this at all, if you're not following him on Twitter X, you are doing it wrong. The best follow for Florida State in general, but specifically with the legal issues, the ACC lawsuits, all of that, the best guy that you should be following on Twitter X.
For sure. Well, let's get into the lawsuits. And I do just want to tell people, we actually had Doug and TJ Pittenger on, and we're going to be doing a Florida State Seminole football preview coming up in a few days as well. So I know we have a bunch of Seminole fans watching this. You're definitely going to watch that because it's fantastic.
We got to talk ball with Doug. That was fantastic.
Yeah, wonderful. But hey, we're back to lawsuits. So let me ask him a question. And this is the one I've been kind of muddling around in my brain, and I don't quite understand it. And there may not be a really good reason, but Doug's going to straighten me out. So Judge Cooper here in Leon County, he hasn't made a stay of the court hearings in his court while there's an appeal process going on there in Leon County. It looks like things are going to be progressing there. Just as a reminder, Judge Bledsoe in North Carolina has put a stay both for FSU and for Clemson in terms of waiting to see what the North Carolina Supreme Court has to say about the appeal process that both of those schools have done. So my question to Doug is, why are we seeing this difference between these two judges, between these two courts? And is this maybe just a normal type of occurrence in Florida? Or is this a special to Judge Cooper? I'm just confused why we're seeing these differences. I'm hoping you can help me straighten this out for me.
So this is a decision that the judge can make on their own. Certainly they have input from both parties as to what they wish and what they desire. But in our cases here are two cases that are pending. North Carolina and the ACC want this to go as slow as possible. They want Florida State and their commitment to stay in the ACC for as long as possible. And in Florida, of course, they're chomping at the bit to make sure that this case gets moving as quickly as possible. And so you're seeing that reflected in both of these orders. Judge Bledsoe, who is retiring, for some people that might be new information, we have a new chief judge that's going to be assigned to the case in December. They have said, look, since you're appealing these foundational issues, jurisdiction and venue, let's just go ahead and pause the entire case. There's no sense in getting into all this stuff if there's a chance the case might be dismissed. Florida, by contrast, is saying, okay, we're putting jurisdiction and venue into the Court of Appeals, and certainly we'll let them decide. They're also dealing with the sovereign immunity statute and whether or not the ACC can sue Florida State in Tallahassee, or vice versa. Should the case be stopped in Florida to go to North Carolina based on the statutes? But in that discussion, they've basically broken off a piece of that cookie and set it aside. Judge Cooper has said, okay, we're not going to touch that part, but we still have the rest of the cookie. We still have everything else. This case is going forward. It's not going to be dismissed. I have a high degree of confidence the Court of Appeals is going to validate my holdings. So let's just go ahead and keep the case moving so that when those other issues are resolved in the manner I expect them to be resolved in, we're not 6 months behind on this litigation. So discovery can still proceed. Depositions can be taken. That's the next thing I expect to come out of his new order, which from 6 weeks ago still hasn't been provided. That's probably our next conversation we're going to have is what are the details in Judge Cooper's orders. But that's what he's going to be setting up next is what does that discovery schedule look like going forward?
Is it odd that it's been 6 weeks and we haven't seen anything yet? That seems like an awful long time.
We have seen Judge Cooper be deliberate in the past. It depends on what else is going on. I certainly don't know what is, what his schedule looks like, or what his trial court has looked like, or what his vacation schedule has looked like. But this is one of the reasons why we said early on, don't expect the process to go quickly. This is going to take a while. We already have his ruling from the bench. We know what he's ruling generally, but now he's reducing it to writing in a manner that he knows the Court of Appeals is going to be looking at that order too. So he wants to dot his I's, cross his T's. And the rumor is from some of my colleagues down there that he does do his own research. He does do his own writing. Most judges have clerks that can bang the stuff out and they just proofread it and change it as they want to see fit later on. So yeah, it's a little bit more tedious, but this is why I still don't think we're going to have anything of substance rendered from a court in terms of a verdict or any decisions anytime this year in 2024.
Okay. All right. Great.
I can just picture Judge Cooper in his office surrounded by binders everywhere, banging away at a typewriter because the computer system is down. That's just what I'm picturing right now.
And this isn't his only case. He's got
Right.
other cases going on. There's other matters that are pending.
Sure.
Okay. All right. So obviously, as a Florida State fan, a lot of your main focus is specifically on the Florida State lawsuits back and forth with the ACC. But obviously, you're at least generally aware, and you comment and follow also on the Clemson case, from what I've seen on Twitter. So now we have 4 cases basically going on in 3 different states. Is that basically, or do we have procedural chaos? Judge Bledsoe in North Carolina said if this were to happen, we'd have chaos, and that seems like we're in the chaos mode right now. So that's my main question for you, and I want to give you my follow-up question with it, so you might be able to just roll right into it. We've talked every time that we've had you on here. I've always asked you about the possible federal case should this ever get to the U.S. Supreme Court, and I think you've basically kind of hedged mostly away from that for various reasons, and maybe left it as a possibility. So, please comment on your thoughts regarding, do we have procedural chaos, and has this, now that we have 4 cases in 3 states, has this changed your thinking at all on the potential of a federal case or the federal Supreme Court eventually getting involved?
All aboard the crazy train. Woo, woo. This is going off the rails quickly. I mean, yes, it is absolute chaos. This is exact worst case scenario, really, for all the parties. You want litigation to proceed in a organized and orderly manner. That's what allows the attorneys to advise their clients on the likelihood of what's going to happen. When you have one judge that you're trying to figure out what they're going to do and how they're going to approach a case, it can be very challenging. I've lost some trials I thought I was going to win. I've won some trials I thought I was going to lose. I just quoted on X 2 weeks ago. Apparently, boneless chicken wings don't need to be boneless, according to the Ohio State Supreme Court. Yeah. So you never know what the judge is going to say. Now we're dealing with 4 judges and what those 4 judges are going to say. So yes, it is chaos. We are at the point of chaos. Again, we don't know what is actually going to be resolved through any litigation. A settlement and an agreement is far more likely to transpire first. But yeah, this has gotten about as sloppy as we expected it would get. And to your question about the federal issue, I hadn't really given it much more thought since our last conversation. Nothing that I've seen or read has encouraged me to change my viewpoint. It seems like it's not. There's no method. There's no module. There's no vehicle to get this yet to the federal court. Now, again, 4 cases go to judgment and go to conclusion 3 years from now. Perhaps that'll change, but these cases are never going to get to trial, let alone to verdict.
So, real quick on a follow up, because the ACC is the only entity here that's having to go to these different states, whereas FSU is only worried about 2 and Clemson's only worried about 2. Do you think that is a benefit to the ACC, that maybe they can play off of different judges' opinions and what they have to say, bringing different things to the table? Or is that a detriment to the ACC? Because, man, they got to your point, they have to deal with 3 different judges that view these things very differently. Maybe there's not a right or wrong there, but would you say it's either a benefit or a detriment to the ACC?
I think it's definitely detrimental, but for the reason that I closed my last tweet out talking about the AG Moody documents and what we're dealing with here, in order for the ACC to win, let me back it up. Let me say it the other way around. Florida State and Clemson are both bringing multiple prongs to their attack. They're bringing multiple, complaint or multiple counts to their complaint. I think Florida State is at like 5 or 6 or 7 counts. Clemson is at 5 or 6 or 7 counts as well. Any one of those claims can defeat the obligation that the schools owe to the conference. By contrast, the ACC has to defend every single one of those counts. So Florida State and Clemson just need to win on 1 count in one of those 4 courts, whereas the ACC, in order to keep everything intact, has to have a clean sweep. That's the issue we have with so many counts in so many different courts.
Makes sense.
Great way to put it.
Thanks. Yeah.
Okay, I still have the next one, right?
Yeah,
Okay.
you're going to go you're going to give him a little bit of a speculative question
Yes.
here.
So this one's more strategy, speculation, maybe not as much of your legal training, but more of your strategic mind. We want to question here. So there's been a lot of talk, and again, you're a obviously a Florida State fan. So beyond your day job as a lawyer there in the Atlanta area, you are a Florida State Seminole fan. You're a Florida State Seminole homer. I'm sure you are. Yeah.
All it.
Unconquered there. Yeah. So there's been a lot of talk, and JY and I have been discussing this on Twitter and some other episodes. There's been all this talk. There was Feinbaum on ESPN saying, oh, Florida State doesn't have a place in the Big Ten. There's been all this speculation and kind of strategically leaked quotes. In my opinion, some of that is maybe to kind of slow the timeline, whatever. But do you believe from a strategy perspective that Florida State, and you followed the board there and you kind of just know the vibe of the donors, the fan base and everything at Florida State, do you think they would have gone this far down this road no matter what, without knowing or having a pretty good idea that they have a definite landing spot? They would have just done this anyways no matter what and gone this far and this hard? Or do you think that it's pretty obvious that they do know that they have a landing spot? Hopefully that question was clear.
I have talked to everyone all the way up to the president. I mean, that's the one thing that's been nice about the newfound fame that you have helped me, provide, obtain in the Florida State fandom. I am a booster, and I do get, exclusive opportunities to meet with Coach Norvell and his staff, and I have been, in the box with the president and with the booster president. Nobody is telling me anything. So this is not coming with any wink, wink, nod, nod. I've heard things. There are 3 people that know the answer to this question, and that's President McCullough, that's Stephen Ponder of the boosters, and probably Coach Norvell. Outside those 3, everybody is just speculating. What I will tell you, to go back to your temperature or vibe approach, the boosters would lose their collective minds if we ended up in the Big 12, because that is viewed as at best a lateral move, and that is not what all of this heartache and expense and fundraising has been about. This is to set up Florida State to get into the Power 2, perhaps take a timeout as an independent for 2 years, waiting for some other pieces to fall into place, but it's not to go to the Big 12. And I'll give you the indication of how concrete and certain I am about that. All of these conferences are worried about tortious interference, getting Florida State into their conference and then being sued by the ACC for all of the, for the millions and potentially billions of dollars of revenue loss. Well, I guess ACC has already said it's 200 million. They've already put the number out there. But the reality is that there will be depositions, and you want to read the Paul Feinbaum quote saying that we're disruptive partners, that we're trash, that nobody would possibly want us. We don't want to, cut our pie into smaller pieces. Those are the kinds of things you want to read in the deposition transcript to show that you didn't have any interest in Florida State while they were a member. By contrast, this trash news about the Big 12, that's the way you know that there's no possible way we're going to end up in the Big 12, because they're saying we'd love to have Florida State. We'd love to have them join us. Well, guess what's going to be read into the transcript at your deposition is you putting out all these press releases. So the only way the Big 12 representatives are comfortable saying that is if they know that there is no chance in the world that that's actually going to happen. They're just trying to elevate their profile, maybe get the Miamis, maybe get the Virginias, get those second tier ACC schools that are looking for a new home once the collapse begins. Oh, well, Florida State and Clemson were talking to the Big 12, so maybe they're not that bad of a landing place. So that was all a PR campaign, and the ACC, SEC, and Big Ten are in a disinformation campaign just so that they can say we had no interest until they announced their departure. And now, sure, we'll be happy to talk to them about what the possibilities are.
That makes so much
It
sense.
does.
Doug, you make so much sense.
Yeah.
That is a perfect answer. And now you say, I sit back like, well, duh.
Yep.
But I you don't think of it. He does. I don't think of it that way. But thank you, setting the record straight. I mean, yes. I mean, and to be clear, I've been on X saying this whole Big 12 stuff is mumbo jumbo, just fire or smoke with no fire, and blah 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 blah.
Yep.
But when you put the
context,
and the understanding of what would actually happen if during a deposition this came out, like, yeah, they're hosed. They can't. Yeah. Anyway,
the last thing the Big Ten and the SEC want is any kind of quotes from a Big Ten president, an even athletic director, anybody associated with the school saying, "Oh yeah, we'd love to get Florida State," because that, like you said,
right,
can be part of an interference, a collusion campaign, whatever. So it makes a lot of sense. I appreciate it, and again, like I said, that was a little outside of we try and go to you for maybe more hard legal stuff, but we really wanted to get your take on that strategy, and you knocked it out of the park.
So last question, and just kind of with the recent developments, and I'll kind of point maybe mostly towards what has now come out because of the AG Moody writ that she and the agreement, I should say, that she then came with with the ACC, and being able to see some of this ESPN ACC Media Rights Contract, lots of redactions. I get that. But has there been anything over the past few weeks pointing to that or other items that maybe has changed your mind on where things are at with FSU, the way forward for FSU? And I know you've been putting some things on X regarding the media rights agreement. So I'd just like to hear maybe if there's anything that has come out of that maybe corroborates anything that we've heard, or maybe changes the mind of some things that we've heard. Where are we at with all that right now?
I think your question was perfect about the corroboration. That to me is the most valuable part of the documents that were provided. Remember what was going on stylistically at the beginning of this lawsuit. Florida State had some documents that they tendered as exhibits to their complaint, the ACC contract or the bylaws, the grant of rights. They had the ACC Constitution. They had a lot of documents that they could include with their complaint to the court. They didn't have the ESPN agreements. They didn't have these multimedia rights because they were under lock and key, because they had not been provided. So Florida State alleged many things in their complaint that a lot of people were skeptical about. A lot of people were wondering, well, what's the basis for it? Yeah, you can allege anything you want. It is true. You can allege whatever you want in a complaint, but understand the judges are going to receive the unredacted copies of these documents. And if you put anything in your complaint that's objectively and provably false, then you're going to lose credibility with the judge. You may even get into ethical trouble because you owe a duty of candor to the court. You're not allowed to lie to the court in your written pleadings. So we knew that Florida State was alleging some very serious things and some eye-opening new things, including this idea that the contract ended in 2027 and that there was a unilateral extension available to ESPN through 2036, but we didn't have any documentation to back that up. Now, with a disclosure from AG Moody's office, we've seen that while redacted, referencing the 2036 dates, the paragraph and the clause about there being a unilateral option by ESPN to extend is in fact in there. And we also have the letter to Jim Phillips where ESPN is exercising within 2 years of the ACC network being launched, an option to extend that option. And that's where we're starting to get into some questions about the legality of such an option, such an extension. what are the actual terms. So the first part and the most important part about this is that it lends credibility to Florida State's allegations about what the contract terms were and how to interpret them. And then the second thing is this issue, this wrench that they've thrown in. Florida State is pointing out that ESPN was supposed to announce an extension through 2027. And then there's this idea that they have until February 1st, 2025 to announce an extension through 2036. Well, what's in those redacted portions? Because we know about the first extension that was agreed to by the party. So we don't need a new multimedia agreement. And we have paragraphs where they're reciting what the payouts are and the amounts being paid through 2027. But where is that authority to extend beyond 2027 into 2036? Was that just a letter brief, a letter agreement between the two parties that was not included in the multimedia agreement? If that's the case, then the members haven't approved that multimedia agreement. They approved the one that included terms up through 2027, but the members need to vote by 2/3 majority on that extension through 2036. Again, depending on what's being redacted. But it sure sounds like from Florida State's complaint that that's the avenue they're taking and that's the angle they're approaching this with.
Well, that's interesting because the last time we had you on, you had to set me straight on, is this an opt-out? Is this just a look-in? It almost sounds like now, and again, JY could be confused, so please correct me. It's not so much an opt-out or a look-in, it's actually an option to extend. So it's almost the exact opposite, at least where I was at. Like, it was like, yeah, it's going to go through 36 and they say, hey, we want out. No, it's not we want out. It's we want in order to go to 2036. And then on top of that, you're saying that the details of that potentially, again, lots of redactions, we don't know, but potentially aren't even in this agreement. And maybe there would have to be another agreement in order to do that. Is that the correct understanding?
That is one potential. Again, the Florida State complaint, and I will be transparent in this. Yes, I'm a homer, and yes, I'm being rose-colored glasses. But Florida State, in their first complaint, said the agreement was through 2036. But you saw with the introduction of the Clemson complaint and their crystallization of this idea that no, once we're out, the grant of rights is expired and non-functioning because the ESPN agreement is non-functioning. It will be curious to see in the next oral argument if there is a change in their language, in their arguments, because it was just like all the media and everybody else was presuming the grant of rights is through 2036, everything else is through 2036. It may not yet have clicked with the Florida State lawyers that no, the recitations in the contract are only through 2027. So I'll leave open the possibility that this is an evolving issue that I can't conclusively state. How can you conclusively state when 85% of the document is redacted?
Yeah.
But it goes back again to some credence applied to the concept that no, this deal may only be through 2027 after all.
And credence in that the lawyers could have seen this agreement again. Like I say this every time we talk, in the special room at the ACC office that is
They can only take notes.
They can only, yeah. So we're seeing it for the first time, or pretty much anybody's seeing it for the first time. But to get back to where you kind of started with answering this question, what they had in their document kind of alluded to this, and so more of that corroboration maybe piece of some of the things that Florida State put into their original briefing. So that's interesting.
Doug, I have a couple follow-up questions there. Do you have more time? Are you okay?
I got about five or 10 minutes max.
Okay, perfect. So the first one should be quick and easy. With the redacted portions, there's been this debate, will AG Moody and everyone else be satisfied with the redacted version? Do you see any avenues? There's things like that we're talking about now, very important, a date in which a public university is contractually obligated. Do you see that being an area where you could push hey, this should be public record, this should be public knowledge? Or do you see the current redactions just staying, everyone agrees, okay, those are trade secrets that should be protected?
I don't agree that they're trade secrets that should be protected, but I think we're out of time to get anything else done about it. If you go back to the documents that were produced, the geographic location of the reach for the conference was blacked out. Well, what is it? Is it the Southeast? Is it the Atlantic Coast Conference? Is it the whole United States? Is it the solar system? That's not a trade secret. You either are or aren't busily getting teams from California into the conference. So that's an example of some of the nonsense you see in what was redacted. But remember, that campaign by the Attorney General's office started, if I remember, back in February. That was when the first requests were actually made. So what she said basically was, I'm going to lose this hearing. I'm going to be embarrassed. So I'll go ahead and cancel the hearing if ESPN, you just send me those documents. Well, why would ESPN do that? Because ESPN is a business too, and they don't want to spend money on attorneys' fees, sending people down to Tallahassee from Bristol if they don't need to. So there was a benefit to ESPN, and all they gave up were the same documents they've already given up to other parties in other litigation. Right. So the AG's office got to say, oh, they've capitulated. No, they didn't. They sent you the documents that they chose what to redact. If this truly was ESPN folding, then the AG's office would have gotten the documents first, seen what was redacted, have a conversation about what should or shouldn't be redacted, and only then cancel the hearing. That's not what happened. So that's how you can know that this was basically the AG's office saying, let's get a public relations win and send out a press release saying all these great things about us. And again, I'm not a Florida voter. I don't have a dog in the fight. This is not a political commentary. I'm calling balls and strikes as a Georgia observer. Sure. The bottom line is that this was a nothing burger from the AG's office.
But as a politician, she can still claim it as a win and move on, which is great for her.
Yeah.
So, all right. So my last follow up here real quick is basically just an opportunity to set you up for a closing statement. Okay. As an attorney in the Atlanta area, part of your job obviously is giving legal advice, but also managing your clients' expectations. Okay.
Yes, very much so.
So I want you to manage the Florida State fans' expectations here, okay? Help us manage that. I've gone on record. I think Florida State is going to be the next member of the Big Ten eventually. It might just not be as quickly as many Florida State fans would hope. So in your mind, as you've seen how these cases have progressed, and we have multiple cases going on, what do you think is a realistic expectation? We have message board posters that are like, they're chomping at the bit. By August 15th, we're making the announcement, fight on, march on, whatever. But what is realistic for Florida State fans as they look, how much longer, should they expect to be in the ACC? And I'm not asking you to give definite timelines, but just help manage realistic expectations. What's realistic to see a settlement, those kind of things? Are we talking, 6 months? Are we talking 3 years from now? Just what should be those realistic expectations?
Nothing in any of the litigation is more important than the ESPN opt-in date. And to finish the JY conversation there, ESPN has to affirmatively opt in. If they don't do anything, if they keep quiet, if they don't say anything, if they don't do anything, this isn't a look-in provision, Commissioner Phillips. This is a unilateral, unobligated extension. ESPN either signs a piece of paper extending this deal through whatever redacted date was on there, presumably 2036, or they don't. And if they don't, then I am very confident in what conclusion I have reached, which is that the grant of rights is tied directly to the ESPN agreement. If there is no ESPN agreement, there is no grant of rights. So the worst case scenario for Florida State fans is anytime between tomorrow morning at 8 a.m. and midnight, probably maybe 5 p.m. on February 1st, 2025, for ESPN to extend the agreement. If that happens, we're in this for the long haul. We're in it for 2 or 3 years before this is resolved or settled for a pretty hefty sum, because then we're litigating the issues. If, however, as I suspect, ESPN says, there is too much going on here, there's too much chaos, there's too much confusion, we can't commit to 9 more years of paying at this premium, even at a below premium option. Remember, Florida ACC might be on sale, but to somebody that's hemorrhaging money and in financial distress, they don't care if anything is on sale. They're trying to figure out how to reduce their expenses. One way ESPN can reduce their expenses is manage a transition from the ACC for Clemson and Florida State to the SEC property. Yes, the pie gets bigger. Yes, they have to pay more, but their return will be exponentially higher because you have more marquee SEC matchups. And then they can cut loose the ACC network. They can cut loose their ACC contract. They can shed all the expenses associated with the other 15 teams that aren't making money for the broadcast partner. So that's one way that I could realistically see this case be resolved, with a timetable of a departure after the 2025 season, the 2026 season. So, because if they don't announce before August 15th, they've got to play all of 2024 and all of 2025. So 2026 would be their first SEC or Big Ten year if either ESPN manipulates the situation, or if simply ESPN gives their blessing and says, we're not going to extend the agreement. They can go off, pay their 1 year of their grant of rights, just like Texas and Oklahoma did, and go off to the Big Ten.
Perfect.
Great.
Well, we thank you, Doug. We've taken a lot of your time this evening. Just as a reminder to everybody, we have another episode coming out with Doug and TJ later this week. FSU preview for the season. It's a lot of fun. I know I was really into it.
Great.
I loved it.
Yep.
So anyway, Doug, thank you so much, sir. Hey, with
Always a
that,
pleasure.
we thank you guys for watching. Give this one a like, subscribe if you like the content. We hope to see you next time on the Big Mountain.